There'll probably be some questions about mootness, but I'd like you to, in focusing on the equal protection analysis, the sex classifications in sports is not being challenged.
That's correct.
How does that work in this case when we're talking about one individual being accepted from a particular or included in a particular category?
There's no basis for heightened scrutiny, intermediate scrutiny in that situation, Your Honor. If the sex-based line passes intermediate scrutiny, which no one disputes that it does, then the edge cases, the potential exceptions, that's all rational basis review.
That makes no sense to me, all right? And I don't know how you can say sex classification is not being challenged. There's no question here that a male who identifies as a female, but it's a male, is being excluded from a female sport, correct?
That's correct.
All right? By its nature, that's a sex classification. And all sex classifications, we have said repeatedly in our case law, require intermediate scrutiny. Now, what you're saying is, well, she's not challenging males generally not playing. She just doesn't want to be the one male excluded. So it's a subclass of people that she's challenging, correct?
Yes, I think that is correct.
All right. So how do you square our various case law, Caban, Lear, Claiborne, VMI in particular, all of whom involved a subclass of people who challenged on equal protection grounds their exclusion from a definition?
I'm happy to take those cases in order, Your Honor, starting with Caban. There was no notion of as-applied anything in Caban. In Caban, it was a facial challenge to the statute, and individual circumstances were used as examples to prove that the statute was overbroad and lacked a substantial fit.
That's the point. That's what she's saying here, that the state interest here is the safety of women, correct? And promoting competition. That's the state interest. And in Caban, the state interest was in ensuring that only children with active parents, let's say, were given a state benefit, correct?
Yes, and Caban was struck down facially. The statute was considered unjustified.
How about Lear?
In Lear, we had the same.
That's the opposite. That's the subclass, the people who were excluded.
In Lear, the court said the law would be justified with respect to you, plaintiff, and because the law would be justified with respect to you, you are not able to challenge the law elsewhere.
All right.
So the
How
court
about
says,
VMI? That distinction doesn't make any sense to me. It's still an exception. It's a subclass of people who are covered by the law and others are not. That's what we said.
the VMI case is the flip side of Idaho's law. The VMI case, equal opportunity required letting women in to previously single-sex spaces. In this case, equal opportunity for women requires giving women separate spaces. And VMI said that was okay. VMI said separate housing.
That's begging the very question at issue here. You can have a sex classification based on sex. You just have to have a reason for it and one that matches your exclusion. What you're trying to say is we don't even look at the reason to see if it has a scientific basis.
The reason we don't look at the reason in this case to see whether there's a scientific basis is because no one disputes that there is a scientific basis for separate sports.
Oh, but there is a dispute of that.
I'm sorry. Are you then saying, Mr. Hurst, that there really is no such thing as an as-applied equal protection challenge?
No, Your Honor, but what I am saying is that equal protection, the question is whether the classification is valid and not whether it makes sense in individual situations.
But